Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. If you've ever had a question about your employment law rights, then you've come to the right place. Welcome to Ask a Lawyer. I'm your host, Dana Levinson. Each week, we dive into different employment-related topics that are on many Canadians' minds. Employment lawyer Lior Samfiero is here once again. Before we get to today's questions and phone calls, Lior, tell us why you believe it's important that everyone know their employment rights and perhaps talk about a significant case that you had this week.
Dana, as an employment lawyer, I often hear people saying, we don't have good laws here, or that the laws are not very favorable to an employee. And people that say that, it's really a function of them not knowing the extent of our employment laws that we have in this province. Let me tell you, in Ontario, we have some of the best employment laws in the world. Employees have a lot of protections, a lot of rights. Unfortunately, there's no easy way to find out what those rights are. And I always say, if you don't know what your rights are, those rights are kind of meaningless, right? The whole point is to know what they are. Well, that's why I think it's important that we on this show give people an opportunity to learn their rights, to understand what they're owed, to understand how the law protects them, because there are protections and there are rights, and hopefully that makes for a better workplace, more educated employees and employers. I think that's a very good thing for everyone, and I speak every day with people that are in difficult financial situations because something went badly in the workplace. By the way, if you're ever in that situation, all of our viewers, give me a call, happy to talk to you. And let me give you an example, and this example actually has to do with summer jobs. So summertime right now, a lot of people may have a job for the summer. Maybe you're a student or maybe otherwise working for the summer, couple months, 3-4 months. So what happens if you have a summer job and your employer doesn't see it through? What happens if they let you go before the end of that summer job, or maybe something changes and the employer says, we're not going to be able to fulfill those obligations? Well, here's the thing. A summer job really is a job for a fixed term, 2 months, 3 months, 4 months. And the rule is this: if you have a fixed term contract and you are let go before the end of the contract, your employer still has to pay you for the balance of that contract. I recently spoke with a young gentleman who had taken a job for 3 months over the summer. On his first day of work, his employer said, something changed, we're not going to be able to have you work here this summer. Well, too late for that employer. That employer now owed the employee for the full 3 months that this person was supposed to work there. So very important for those of you working summer jobs, but also very important for anyone on a fixed term contract. Sometimes that contract could be for 3 years or 4 years. If you are let go before the end of that contract, your severance is the equivalent of the balance of the contract. That could potentially be years of pay. So this is what I mean. Employment laws in this province are quite good.
Okay, if you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Let's kick things off by taking our first call from one of your radio shows across Ontario and the country, where you take live questions from listeners about their employment law issues. Let's take a listen.
I was let go with no warning after 4 years of service. My question is, I only got 3 weeks of severance. I didn't get anything else. I'm just wondering if I'm entitled to anything more, perhaps. I'm 58 years old. The job was a customer service rep.
Now, I think a lot of people would say that being let go without any warning is not fair, it's not right. And I can agree from a business standpoint, even from an ethical standpoint. From a legal standpoint, though, yes, his employer can let him go without any warning or really without any reason, so long as they pay proper severance. I know for some people that may be very surprising, but your employer is able to let you go pretty much for any reason, but severance has to be paid. So the real question here is, did they pay him proper severance? Is the 3 weeks pay that they gave him, is that enough? It's not enough. It's not even close to being enough. So how can this person find out and anyone find out how much severance they're actually owed, the real amount, not what they've been offered? what the law says you should have. Easy. Just go to PocketEmploymentLawyer.ca, use our severance calculator tool there. It's free and anonymous. Let's do that right now for that particular scenario. So we know that this person worked there for 4 years in a customer rep position. He's 58 years of age. He was offered 3-week severance. What a generous offer. No, not generous. You can see on the screen right there, he's owed 6 months of severance. Now, if I did some calculation. If this person's salary is, let's say, $62,000 a year, that right there is a difference of nearly $30,000. That's how much that difference is between what he was paid 3 weeks, what he's owed 6 months. That's a wrongful dismissal, Dana.
Okay, wow. Let's take a short break. And when we come back, employment lawyer Layoffs from EmploymentLawyer.ca will identify workplace red flags and how to deal with them. More in just a moment. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Employment lawyer Lior from EmploymentLawyer.ca is taking your employment law questions. If you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We have more calls and questions coming in, Lior, but before we jump to those, let's talk about today's main topic, employment law red flags. Let's go through some of the top ones, okay? Employment flag number 1. Despite many stellar performance reviews, your employer puts you on a performance improvement plan.
So we're talking about situations where if you find yourself in one of those, you should be concerned. You can't just ignore it. You should do something about it. So these are important situations to keep in mind. And the first one, being put on a performance improvement plan when you really don't feel it's justified. Usually when an employer puts you on a performance improvement plan, it's a step towards trying to let you go and potentially letting you go for cause. So the problem here is this: if you don't say anything, if you're put on a performance improvement plan, you don't agree with it, but you don't say anything, you want to be the team player, maybe it's uncomfortable, so you just put your head down and continue working, you may as well have said, I agree and I accept this. And the problem with that, if you agree and accept it, that later on they can use that against you if they want to try to terminate you for cause. So what do you do if you get this unjustified performance improvement plan? I want you to send your employer an email or a text message. Email works really well, saying, here's why I don't agree with it. Here's what actually happened, or here's why my performance was not what you said. I don't agree with that. Now, you don't have to be rude or aggressive, not at all. But it's important to put your position on the record so no one can say, yeah, you accepted it. By doing that, you're going to make it that much more difficult for your employer to let you go for cause. So it's very, very important that you respond. Not answering simply should not be an option in that situation.
Okay, employment law red flag number 2. Your employer gives you half a colleague's workload and moves you to an office much further from your home.
We can have given other examples here, but what we're trying to say is your employer is really kind of giving you that nudge that they want you gone. They're changing your job, they're making it difficult to work. Well, we're going to also move you to a different office and different location. They want you gone. Well, what they're really trying to do here is they're trying to get you to quit to avoid having to pay you severance. But here's the thing. If you were to leave in that type of a situation, it's really a constructive dismissal, because you're not leaving because you want to spend more time on the golf course. You're leaving because your employer has made your work situation that much more difficult, and maybe it's a poison environment now. And because of that, the law says that's not right. That's a constructive dismissal. So if you find that your employer is trying to push you out, if you can show that, that's a constructive dismissal. Your employer is still going to have to pay you your full severance.
Okay, our third employment law red flag. After years on the job, your boss wants you to sign a new employment contract.
Talk about red flags, Dana. Absolutely. It's never, ever good or good news or a good idea to sign a new employment agreement once you're already working. And if your employer all of a sudden wants you to sign on a new agreement, there's a reason for that. And the reason is that the terms in that new employment agreement are much better for your employer. For example, it may contain language that limits your future severance. At some point, that could cost you tens of thousands of dollars, maybe even hundreds of thousands of dollars. There could be a term there that allows the company to change your job or to put you on a temporary layoff. So it's a very concerning thing every time you're presented with brand new employment agreement for no reason. So it's okay to say no. You don't have to sign it. You can't be penalized for refusing to sign it. At a bare minimum, let me see it. Let me tell you what it means, what it says, and what it does. If you sign it, you have to be prepared to live with it, and that could cost you literally a lot of money down the road.
Wow, okay. Employment law red flag number 4. The company continues to ignore your request to investigate sexual harassment by a coworker.
So harassment, sexual harassment or other harassment is a big deal, and an employer can't ignore that. So if your employer is not doing its job, you may need to force your employer to do that. You have a right, every employee does, to work in a safe work environment, in a harassment-free environment, and not to be in that poisoned situation, certainly sexual harassment. So if your employer won't deal with that situation, I can give them the proverbial kick in the pants, so to speak, to get them to do that. Or that may be a human rights violation, a constructive dismissal. There's a lot of remedies that are available to an employee where the employer is dropping the ball on their harassment situation. What I don't want you to do is assume that you don't have a choice and just put your head down and continue working. No one should ever be put in that situation.
Okay, our last employment law red flag. Your employer says you're not the right fit and fires you for cause.
So you're not the right fit. What does that really mean? And you know what? Let's give the employer the benefit of the doubt. Maybe you're not the right fit. Maybe it's just not working out. Does that mean that the employer can let you go for cause? No, not at all. Remember, we've said this on previous shows. It is extremely difficult to terminate employment for cause. It's reserved for the worst offenders. So just because you're not the right fit, maybe you are, maybe you're not, does not mean you can be deprived of severance. So those words, not the right fit, does not mean you don't get your severance. If you hear those words, you should still think severance. That severance can be 6 months, 18 months, it could be as much as 24 months. And unless you did something terrible, you have to get paid that full amount.
Okay, let's listen to another phone call from one of your radio shows. Take a listen.
What's the basic amount of time for someone to be eligible for severance pay? Because, for instance, they put some people on layoffs. I've noticed that layoffs only means 6 months before a person can reapply again if they're still interested in working at that place.
Dana, this is kind of frustrating because I've said before, there's so many misconceptions, myths, half-truths when it comes to employment law. So this is one of them, that if I'm put on a temporary layoff, I have to wait a certain number of time before I can do something about it. No. Let's talk about temporary layoffs. If you're put on a temporary layoff, you have a right to treat that layoff as a termination. And you can get your severance. You don't have to wait. You don't have to see what the company does. You can choose to do that, or you can treat that as a termination. So there's no minimum time that you have to wait. It's not 6 weeks, 3 weeks, whatever it is. You can decide now. I'm treating it as a termination. Beyond that, if you lose your job, you have up to 2 years to pursue your severance. There's a 2-year limitation period here. So don't worry about deadlines. Don't worry about timelines. As long as you're not up against that 2-year limitation period, you can do something about it. And I would say you must do something about it.
Let's take a short break, and when we come back, Lior from EmploymentLawyer.ca talks about the countdown clock on a severance offer. Don't go away. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Lior Samfiru from EmploymentLawyer.ca is taking questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888 861-4555, email ask@employmentlawyer.ca, or visit their website, EmploymentLawyer.ca. We still have lots more to discuss. Here's another call from one of your radio shows.
I was on PIP about 7-8 months ago. I was warned by an email. Then after 6 months, they just let me go with 8-week severance. Just the office job. About 10 years. Am I entitled for anything extra?
So we're talking about performance improvement plans in a previous segment, and the fact that it is usually a step an employer does before they try to let you go for cause. That's exactly what happened here. So even if the performance improvement plan was legitimate, obviously I don't have a way of knowing that right now, it's still unbelievably difficult to terminate someone for cause, especially after 10 years of employment. That person would have had to do something very bad. They almost would have had to deliberately do a bad job in order to be let go for cause without severance. So chances are, as I've said, this person is owed his full severance. And because of that, he's been wrongfully dismissed if he didn't get that. The question, of course, makes sense. How much severance is he owed? You know that. Hopefully our viewers know. We're going to go to pocketemploymentlawyer.ca. We're going to show you how this person and you at home can find out exactly how much severance you're owed at pocketemploymentlawyer.ca. Let's do that right now. Supervisor Roll, been there for 10 years, 53 years of age, who was offered 8 weeks. Company says, we're generous. We don't have to pay you anything, but we're offering you 8 weeks. You can see on the screen he's owed about 14 months of pay. And again, I like to crunch some numbers. If his salary is $70,000, that's a difference of $70,000. That's a year's pay here that he's owed, an extra year's pay. So that's why it's so important to understand. You cannot be deprived of your severance. 6 months, 8 months, 24 months. You can't be deprived unless you do something terrible.
Okay, here's another question your firm has encountered. I took a few days off last week because of a bad fever. My new manager thought was simply trying to avoid work and fired me. She did offer me 7 weeks of severance for 6 years of service, but with a rule. For every day I fail to accept the offer, she will remove 1 week's pay from the total.
Well, what is this employer thinking, Dana? Seriously, these days you fire someone because they have a fever and they don't show up for work? Clearly, right now, these days, with the pandemic, your employer should not allow you to come into work if you have a fever, even if you want to. So right off the bat, that's a problem, and potentially could be a human rights violation as well by firing this person while they're sick because they're sick. Illegal. The other thing, of course, is this person, after those years, 6 years of service, is owed much more than 7 weeks of pay. Probably owed 8 months, 9 months of severance, not weeks. The other thing is this whole idea of, well, if you don't accept it, well, the offer gets worse. That's ridiculous. The law decides how much severance she is owed. I don't decide, the employer doesn't decide, and it doesn't change if he doesn't accept by the deadline. Every severance offer has a deadline. Those deadlines are meaningless. Your rights don't expire Friday at 5 or Tuesday at 3. You have 2 years to pursue your rights. So it's a pressure tactic. That's all it is. Don't fall for it. Once you sign, because of that pressure tactic, there's no going back. There's no changing your mind. You only have one chance to do this right. So call me. Let's have a chat about that. Let's make sure you get everything the law says you should have.
Those pressure tactics seem more common than not.
It is extremely common, and it works for many people. An employer counts on it working. Well, I'm hoping our viewers now understand it's not legal, it's not right, and they won't fall for it.
Okay, let's take a short pause here, and when we come back with Lior Simfuro, partner at EmploymentLawyer.ca, and address long-term disability claim denials and dishonest terminations. Stay with us. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Lior Sapiro from EmploymentLawyer.ca is answering your employment law questions. You can connect with his team by calling 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Here's another question, this one related to disability. My partner's long-term disability claim for severe vertigo was recently cut off, despite her doctor's recommendations, and now her boss is harassing her, trying to convince her to resign. What should she do?
Very difficult situation, unfortunate, but the good news is the insurance company, number one, can be dealt with. If your doctor says you cannot work, your insurance company should not be cutting you off. We have a whole team at the office dealing exclusively with disability issues and insurance issues to make sure that you get the compensation that you're owed if your insurance company cuts you off. Number one. Number two is your doctor matters here. So if your doctor says you cannot work, that's all that should matter to your employer. If your employer does anything to you in a situation where you cannot work, you have to give me a call. It can be resolved, and you should not accept anything less.
Okay, time for one last scenario that your team handled recently. A few months ago, after taking a 20% pay cut, my employer let me go. They blamed it on lower sales due to COVID. However, at the same time I was let go, they hired 3 new people in my department. Was I wrongfully dismissed?
Keep in mind, this certainly looks to me like a bad faith pay cut. If you're taking a pay cut, or you're being given a pay cut, your employer clearly doesn't need to cut your pay because they're hiring someone else. Now they're going to try to save money on severance by reducing your pay. Not right. So number one is that pay cut is not going to be reducing your severance because it's in bad faith. And in addition to that, your employer may have to pay additional damages because they're not doing this correctly. So this employer really did make a big mistake. And the other thing I want everyone to understand, if you're facing a significant pay cut, 20% is significant. It's huge. You can treat that as a termination of your employment. It's a constructive dismissal. You don't have to accept it. You don't want to give your employer that power to reduce your pay. If you're ever in that situation, if you want to know if constructive dismissal is an option for you, give me a call.
Lior, thank you so much for being here today. You can catch legal experts from EmploymentLawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show and EmploymentLawyer.ca, visit cp24.com/askalawyer. Join us again next week as we identify the worst times for an employer to fire someone. Thanks for watching.